partisan and non-profit civil society that focus on political and democracy education for all Malaysians, especially the youth. So this is a research institute run by mostly younger generation that will inherit Malaysia from the old generation. And Reform is also forecasting to be a parliamentary monitoring organization in Malaysia. And we do hope that Reform will play a key role in reforming and bettering the position and status of the working of parliament in this country, as well as democracy. Okay? So that's the introduction for the organizer of the webinar. So now we're going to see what are we going to have tonight, and the purpose of we having this webinar. So we are here actually to discuss about discussion that are raging now, that are revolving on proclamation of emergency, which was announced on 12 January 2021, and the 2021 Emergency Ordinance issued on 14 January 2021. So the issue of emergency has been extensively discussed, by the people, and there are many sections, in the society have talked about it and have a webinar on it. So, but we can see now at the moment, people had already sort of like come into term with the proclamation. Even though we know that there are still a lot of surrounding mystery on the proclamation of the emergency. Today we are specifically looking at the Emergency Essential Power Ordinance 2021, and we will at the same time try to understand the specific impact of the ordinance. First, the impact on Article 4.1 regarding the supremacy of the Constitution, and secondly, on Parliament power as stated in Article 55 of the Constitution, as well as Article 150(2)(d) of the Federal Constitution. So here we are actually concerned about the implication of the proclamation, the ordinance on the protection of rights of the citizen, as well as the role of Parliament as an oversight institution over executive function. So this is our discussion will basically revolve around these two main key issues. So I will introduce our panelists for tonight. We have two prominent speakers with us. Someone who are well known in legal fraternity, and at the same time, we have our Tan Sri Malanjun, the former Chief Justice, our special guest tonight. So I think Tan Sri Mohamad Ariff Yusuf need not be given that lengthy introduction. People know him as a reformist for Parliament when he is the Speaker of the House of Representatives. I think he also a Court of Appeal judge. We believe with us a landmark decision on Perak constitutional crisis at that time. Tan Sri Nizar case. And I think the biggest contribution that I, as an academic, regards for Tan Sri Yusuf is the book on parliamentary procedure, because we academicians always read Abdullah Ayub books that have been written in 1970s. So now we have a new thick book on Dewan Rakyat at the House of Representatives of Malaysia. So, and but Tan Sri also now is a consultant at legal firm, Choi and Company and Cheng and Ariff. So Tan Sri still maintain his interest in legal practice. So our second speaker, Dato Sri Muhammad Hishamudin Yunus, I think also need not to be given a lengthy introduction. He has this UKM4 case, the famous case, in which at that time, I'm also helping the university, to defend the university for that particular case, behind the scene. So he's a Court of Appeal judge, and at the moment he is the chairman of the Competition Commission, also Suhakam Commissioner, and at the same time consultant with Bezas Rosli Dahlan Sarvanan Partnership. Okay, so we have two prominent figures, okay, in the legal fraternity, also, okay, in parliament practice. So with that, okay, I think we'll start, okay, the discussion. Or as a reminder, if, okay, anybody has a questions, okay, to ask, so you can write it in the chat section. Okay, the organizer team, okay, will have a look at it, and they will then, okay, deliver it to me, okay, to be read during the question and answer section. So we will have this discussion in two rounds. I will start, okay, the first round, okay, with Sri Ariff. Okay, so I think as I've stated, okay, in the introduction, okay, we are going to discuss, our discussion will revolve around, okay, Article 150(2)(b), okay, which is, okay, what is, okay, the implication, okay, of, okay, the declaration, okay, with regards to the lawmaking power of Parliament, okay, and, okay, the Yang di-Pertuan Agong power, okay, in terms of his legislative power, okay, when an emergency has been proclaimed. Okay, so I think with that, okay, we start up with I hand over, okay, the discussion to Sri Ariff.
Assalamualaikum warahmatullahi wabarakatuh. Good evening, everyone. I must thank Reform for inviting me to this evening's webinar. Everything now is conducted through webinars. So I'm very grateful we are still able to discuss intellectually on various topics, and including the topic today, which is of great interest, I think, to the populace in Malaysia. And I understand the focus today is on the legislative function of Parliament in the context of the emergency provisions and the Emergency Ordinance that has been promulgated recently. And once you speak about the power of Parliament in the context of an emergency situation such as we have now, we run smack into several provisions. The more notable of which is, of course, Article 150, Clause 2B, which hasn't existed since the first day the Merdeka Constitution took effect. This is a recent amendment in 1981. So we're looking at something which has put a gloss on the original provision. If you permit me, Prof, before I go into the nitty-gritty of the provisions, in a general sort of way, because this is a webinar, and I don't think we're going to treat this as an academic exercise in the university, but to put it in context so that everyone will understand where our Parliament stands in the context of an emergency, where it should stand, how it should stand in the context of emergency. Let me place it in context. What are emergency powers? We can have all sorts of emergencies. Administrative emergencies, very drastic emergencies, something called emergency in Burma, which is not quite the same as what we have here. So it is a very wide term, so we have to be very careful in addressing this topic and putting it in the context of Malaysia. It is quite often, it's repeated very, very often, that an emergency within the context of a constitution refers to an unusual situation requiring urgent action, including, of course, in that context, urgent legislation. Many cases have cited the old, I take it to a very old Indian Supreme Court decision, 1931, Bhagat Singh versus King Emperor. We keep on repeating this formula. And that case says, an emergency is a state of matters calling for drastic action. Doesn't say very much, does it? But this is the formula that our judges have used over the ages, over the last 60 odd years, more than 60 years. Notably, that was applied in Stephen Kalung Ningkan versus Government of Malaysia. Who hasn't heard of Stephen Kalung Ningkan versus Government of Malaysia? So it is very much alive today. And today, with the emergency on, this new emergency, people are looking back, rereading Stephen Kalung Ningkan versus Government of Malaysia, trying to see what exactly was his the position taken by the numerous judges at various levels on things like, is proclamation of emergency justiciable, for instance, and things like that. So the term emergency can cover a multitude of events, so it is said. A wide range of situations and occurrences are caught within the term emergency in a general sort of way. Diverse events such as wars, famines, earthquakes, floods, epidemics, and the collapse of civil government. It mentions epidemics, it doesn't mention pandemic. I suppose the greater includes the lesser, so it shows you that one can never find an all-embracing term covering all sorts of situations. But all said and done, no matter how wide the term is, how wide the concept is, we must not forget the events that we are addressing have per se to be very exceptional. In the words of our federal constitution, the emergency must be a grave emergency. It's not any emergency. It's not because we have a health emergency, therefore it must mean an emergency within the context of Article 150. It must be a grave health emergency or economic emergency. And further, I think we have to be careful here because there's a lot of loose discussion sometimes, as if everything will fall within the purview of Article 150. We mustn't forget that grave situation must relate to three basic features of national life. So there must be a threat, whether imminent or actual, to three basic features of national life. I mean, to assist the listeners to remember what are these, think SOP. But here I would like to invite the listeners to think SEP. What is SEP? One is security for the S. E relates to economic life. P relates to public order. That's all. We cannot enlarge these categories. There could be situations where maybe a pandemic can fall under economic life, or can even fall under security, might not fall under public order. But whatever it is, that is the scope of emergency powers. You cannot add here and there. Now, in such an exceptional situation, generally speaking, we will find an enlargement of executive powers. It happens in all countries throughout the world. Executive powers will be enlarged. At what expense? At the expense of the legislative power of the state. In our case, Parliament. And we see it all the time. Increase of executive power, a lessening of legislative power. In this case, Parliament. However, again, one must caution oneself, this adjustment or realignment of state power between executive and legislative should be temporary. I've purposely left out the judicial branch. Now, we see that in our constitution, the judicial branch has been left fairly intact throughout the numerous proclamations of emergency, and including the current emergency. The ordinance has got nothing to say about the judicial branch. It is presumed to be still operating as per usual. As I was saying, this adjustment or realignment should be temporary. And what does that show? It shows that it cannot be a necessary effect that come an emergency, the democratic character of government suddenly converts itself into an autocratic state with all powers centered in the executive branch. It can never be, because it's temporary. And and people will realize the scheme of Article 150 in the context of our own parliament ensures that this cannot be done. But again, you may say it depends on how we read the constitution, but I'm inviting listeners to look and read the constitution within this context. You can read it any way you want, even saying that parliament can be suspended. But I would dare say, because of the scheme of the constitution, our parliament cannot and ought not to be taken as suspended. That is the context in which I would like to address your question, Prof. So that is a brief context. Now, 150 clause 2B used to be clearer in the post-Merdeka provisions of Article 150. But there were major adjustments over the years, especially the constitutional amendment in 1981. by which the control or the position of Parliament as a control mechanism has been eroded. There's no other way I can describe it. It has been eroded compared to the 1957 position. Let's look at the 1957 original clause 2. What does it say? It's very short, but it is clear. It says, if Parliament is not sitting when the proclamation of emergency is issued, the Agong shall summon Parliament as soon as may be practicable. This is what it says. You can have proclamation of emergency issued, but if the Parliament is not sitting, the Yang di-Tuan Agong shall summon Parliament as soon as may be practicable. And it goes on to say, in the meantime, and until both houses are sitting, the Agong, meaning the executive here, may promulgate laws having the force of law if satisfied that immediate action is required. So you see the position of our Parliament is recognized immediately. You have to summon Parliament. So there cannot be a suspension. If it allows for a suspension, what's the point of using the terms? It must be summoned as soon as may be practicable. Nowadays, however, after the 1981 amendment, the wording is very different. I'm sure a lot of people have been reading and rereading and trying to make sense of this clause 2B. So have I. Now, what exactly does it mean? What exactly does it imply? What does it say? The power to promulgate ordinances is now vested, of course, in the executive. When the proclamation of emergency is declared, read Yang di-Tuan Agong as executive, it's quite clear. The power resides in the executive when the proclamation of emergency is declared, except where both houses of Parliament are sitting concurrently. What does it mean? I get asked this question very often, even from members in this group. What does it mean? Except when both houses of Parliament are sitting concurrently. Does it imply that both the Dewan Negara and the Dewan Rakyat have to be physically assembled together and conducting business simultaneously or concurrently at the same time? Let's say at the same time. Parliament is summoned to meet and they sit at the same time. It's not impossible, though. It has happened. But very rarely that Dewan Negara and Dewan Rakyat sits concurrently. Yeah, it can happen. In fact, the Dewan Negara and Dewan Rakyat can sit jointly, especially during the time when we have the state opening of Parliament and the speech by His Majesty Yang di-Tuan Agong. We all sit jointly. As Speaker, I would sit in one corner. Next to me will be the President of the Senate, and everyone sits in the same chamber, that is in the Dewan Rakyat chamber. Both your members of Parliament and the senators will sit together in a joint sitting. But 2B doesn't mention joint sitting. It mentions concurrent sitting. Now that is quite a term to grapple with. You will see that maybe concurrent can have an adverse effect on the control of Parliament over ordinances, or even the proclamations of emergency, or even the laying of the ordinance and the emergency before both houses of Parliament. But that's another aspect. But concurrently means, I think, if there is an urgent need to declare an emergency or to promulgate ordinances, you can do it on a Friday or on a Saturday, when obviously both houses do not meet, let alone to meet concurrently. All right? I'm sure if you check your handset, you'll find some occasions where this has been done. Yeah? It doesn't meet concurrently. Now, in such a situation, the executive, of course, can take immediate action if certain circumstances exist. This is exactly from the clause. And ordinances may be promulgated as circumstances appear to the Yang di-Tuan Agong to require. You enlarge the scope of executive power, you lessen the scope of parliamentary control by ensuring that it has, by requiring that both houses meet concurrently, and then you have very wide words. to the effect the executive can take immediate action under certain circumstances, and ordinances may be promulgated as circumstances appear to the executive to require. We can argue for quite a number of hours just on these terms, but that is the context. But obviously, if you look at 2B, whatever may be the phraseology, the intent is to allow the executive to have lawmaking power temporarily until Parliament meets. This happened, of course, in 1969, following the civil disorder of May 13, 1969. Parliament did not meet until 22 months later. But this was a very unusual situation. There was no Parliament to start with because of the civil disturbance. The election process hadn't come to an end. There were no MPs being sworn and all that. We had the classic emergency situation, civil disturbance, a public order situation, a security situation. The Parliament could not meet physically until 2 months had elapsed and things were formalized. But even so, it shows you that a situation of emergency has to be regarded as temporary, whether it's 2 months or 22 months. Finally, Parliament must sit. Now, to understand the entire constitutional scheme, I think 2B must also be read in conjunction with Clause 3. Otherwise, it doesn't make sense. Why are we bothered about 2B? You must look at Clause 3. Clause 3 makes it a mandatory requirement that the proclamation of emergency and any ordinances promulgated shall be laid before both houses of Parliament. And once laid, Parliament may annul either or both, if it so resolves. Alternatively, Parliament may choose not to annul this. And strangely, in our federal constitution, we can have a number of emergencies operating and enforced concurrently. That has happened in the past. We had, prior to 2011, 3 emergency proclamations in force: 1966 proclamation, 1969 proclamation, and the 1977 proclamation. That's a long history there. 1966, Stephen Kaloningkan and the problem in Sarawak. 69, May 13. 1977, we have the Kelantan direct rule episode, emergency in Kelantan. So for so many years, we had all these 3 still in force until one fine day in November 2011, resolutions were passed by both houses to annul these proclamations. That is how it should work. Parliament having the final say on whether a proclamation of emergency or an ordinance for that matter should be annulled. I mean, means being regarded as no longer in force. But you see, clause 3 is also not a very easy clause to analyze. Laid before both houses. What does the term mean? Does it mean just to lay it on the table, treat it as a statutory instrument of some sort, place it before the MPs or senators, and you leave it at that? Or does it connote something more than that? I cannot find very clear answers here. I've been trying to locate or to ascertain whether the last 2 proclamations of emergency and ordinances related to the last 2 emergencies, last 3 actually, before the current emergency, have been laid before both houses of Parliament in the term understood under Clause 3. Some people, the other day I was a bit shocked. There was one person who said, late means late, literally. Late before both houses, you put it on the table, is late. Don't need to do anything about it. The legal requirement is satisfied. Is it so? That's what I want to have this matter raised and discussed academically, and of course it will have its effect. If it is just to lay it on the table and forget about it, then where is that element of control by Parliament? In the context of emergency, in the context of 2B and Clause 3, Parliament has a role to play. When a matter is laid before the Houses, of course, within the context of the Constitution, it is expected that Parliament or members thereof must have a say in deciding.
Seri. Yeah, I think I will just stop you there.
Okay.
We will continue later with that last statement that you read. So I will move to Dato Seri Hisham. Okay, so I think Tan Sri already laid down the context of the discussion, the scope of clause 2B of the Constitution, read together with clause 1503. Probably we'll come back to 1503 later. Okay, so and now we will look at the only so far the only ordinance passed under clause 2B. Okay, the 2031. ESPO, the 2021 ordinance. Okay, so and relating to what Tan Sri had discussed, it seems like the Constitution as the supreme law of the country. Okay, so how does in Dato Sri understanding, how does this 2021 ordinance, emergency ordinance, what is the impact that it has on the supremacy of the Constitution? Okay, so is it totally submerge the constitutional supremacy, or actually we can find a way to maneuver how to still claim that the proclamation the ordinance does not to a certain extent derogate constitutional supremacy. So to you,
Assalamualaikum warahmatullahi wabarakatuh dan salam sejahtera. Thank you, Prof. Datin Farida, for the question. And I'm indeed honored and delighted to be here today with my brothers from the bench, Tan Sri Richard Malanjun and Tan Sri Ariff. Thank you to Reform for the invitation. Tan Sri Ariff, you mentioned tadi the judiciary left intact. Betul, you were left intact. Judiciary left intact during a state emergency, but with our time, with their hands tied at the back with an ouster clause. Yes. The second part of the question, Prof, I will deal with the second part of the question, which to me is framed quite interestingly. For it is hard to imagine a situation where the supremacy of the Constitution is totally submerged. Let me explain why. The idea or concept of supremacy of the Constitution is not one which is carved in stone. It's a living concept. It means that the Constitution, the Parliament of Malaysia, is the highest law in Malaysia. In our country, this concept is housed in Article 4 of the Constitution, which says that any law inconsistent with this Constitution is null and void. Now, even at times of emergency, despite the emergency ordinance, there's only one ordinance so far, kan? The Constitution remains the highest law. If any citizens' rights, their fundamental liberties under Part 1 of the Constitution have been wrongly infringed, they can sue the government or public authorities for remedies. Therefore, it is not quite accurate to say that because of the emergency, we have lost our fundamental rights as citizens, or the government and public authorities can do whatever they wish. That is not true. All organs and institutions established under the Constitution must still act in accordance with the confines of the Constitution and the law. Thus, to answer the second part of the question, the supremacy of the Constitution is not submerged in a state of during a proclamation of emergency. But on the second part of the question, that is, does the emergency ordinance have a far-reaching impact on the supremacy of the Constitution? May I begin by saying that the emergency ordinance in itself is a product of the Constitution envisaged and engineered by the drafters of our constitution. It is a unique mechanism provided by the constitution itself. So the proclamation of emergency and the emergency ordinance were both ex facie lawfully promulgated under Article 150 of the Constitution. No, I use the word ex facie here because I'm not taking any position, because I know at the moment there are litigation, so these issues are going to be litigated before the court. So I don't want to be found, breaching the sub judice rule. So I use the word here ex facie. Ex facie means on the face of it lawfully lah. So on the face of it, the promulgation of the emergency ordinance therefore does not ex facie run counter with the supremacy of the constitution. It is in fact affirms the concept. It means that when the government needs to take drastic measures to manage the emergency which arises, it can be a war, natural disaster, civil unrest, or terrorism, it has to first declare an emergency in accordance with the requirements in Article 150 before those drastic measures can be taken. However, procedural compliance and substantive compliance are two different matters. I take the view that if the content of the emergency ordinance is inconsistent with the basic structure of the Constitution, the spirit or core values of the Constitution, then the consequence is that the concept of supremacy of the Constitution will be eroded. I do not intend to put up any conclusive findings for the purpose of today's discussion, but upon a perusal of the emergency ordinance, there are provisions which may raise questions of constitutionality. I repeat, there are questions that may raise questions of constitutionality. For example, take Section 5, subsection 2 of the ordinance. They state that the assessment of compensation for taking possession of any property cannot be questioned in any court on any ground. This is an ouster clause. This may be in conflict with the concept of judicial power and the power of judicial review by the courts. These two concepts have been confirmed as basic features of the Constitution. Therefore, Section 5, subsection 2, as it stands, may have violated the basic structure of the Constitution. Let's argue that it is all right because Article 150, Clause 6 says that an emergency ordinance may be inconsistent with the provisions of the Constitution. But I would say that that is different from the phrase code, inconsistent with this Constitution code, housed in Article 4 of the Constitution. Therefore, the words code, this Constitution close code, contains not only the letters of the law, the provisions, but also the intrinsic values and the basic structure of the Constitution. Another example is this: Sections 12 and 14 of the ordinance can also be questioned. These provisions essentially suspended Parliament. Parliament plays an important role in the doctrine of separation of powers. It acts as a check and balance to the executive. And the separation of powers doctrine is part of the basic structure of the Constitution. In other words, the decision to suspend Parliament can be called into question if it offends the Constitution. In my view, there must be a reasonable justification for the suspension of Parliament and prevention of Parliament from discharging its constitutional function. It can be questioned whether the measures of suspending Parliament were exercised in good faith or bad faith, or are these measures absolutely necessary in light of the emergency the country is facing? If the ordinance impedes the function of Parliament without reasonable justification, that can be an erosion of the supremacy of the Constitution, because Parliament, its powers and functions are all provided for under the Federal Constitution. If I may venture further, Article 153, Clause 3 of the Federal Constitution in itself provides that Parliament shall act as an oversight body over the proclamation of an emergency and emergency ordinance promulgated by the King. Now, that sections 12 and 14 of the ordinance prevents Parliament from sitting. There must be a strong and reasonable justification for this provision to subsist. Otherwise, these provisions may override Article 150, Clause 3, and that will offend not only Article 150 itself, which itself is the source of authority for the proclamation and ordinance, but also the supremacy of the Constitution. Now, regardless of whether or not these provisions erode the idea of the supremacy of the Constitution, these laws are, for the time being, are to be presumed valid, presumption of constitutionality, valid until and unless these provisions are tested in courts and their inconsistency with the Constitution have been declared judicially. That concludes, Prof, my response to the first question. Thank you.
Okay, thank you, Tan Sri. Dato Sri. So I'll go back to Tan Sri. I think then we can see that, okay, because Dato Sri mentioned about, okay, the basic structure, okay, and Parliament is given the power to check on executive, okay, how does executive conduct their business, okay, and Dato Sri repeatedly says it's ex facie, okay. But now I think we'll go back to Tan Sri, okay, so an expert on the working of Parliament, okay. So in line with what had been said by Dato Sri, okay. So what do you think is, okay, actually the implication of section 11, 12, 13, 14, and 15 of the 2021 ordinance on, okay, Parliament power in terms of the actual working of Parliament, okay, the actual working of Parliament. Does it actually that act, okay, actually suspended Parliament? Because, okay, we know that after looking at the Constitution, I don't see that the Constitution mentioned about suspension or to suspend the Parliament. The Constitution only talk about prorogue or dissolve. So there is only two options, okay, for the Yang Di-Pertuan Agong, for the Prime Minister, is to prorogue or to dissolve Parliament. So, but now it seems like the word suspend, okay, digantung, have been repeatedly used by the Prime Minister and most of the executive. So what do you think, Tan Sri, about this situation?
Yeah, again, we have a very strong statement by a court, Supreme Court, in 1976. Quite often ignored, but it is still there, and no one has said the statement is wrong. In the case of PP versus Kong Teng Ken, it was said, the ultimate right to decide if an emergency exists or has ceased to exist remains with Parliament. So this is a judicial acknowledgement of the position of Parliament in the context of an emergency. So when you look at it this way, all the interlocking provisions will come to light, and we don't lose sight of the general overarching principle. Why is it so important? Because I think Dato Sri Hisham mentioned earlier, separation of powers, basic structure doctrine. Certain things simply cannot be done away with. So when we look at the ordinance and study the various provisions that we have now, we have to look at it in that context. So sections 11, 12, 13, 14, and 15 are worth studying very carefully, actually. We can't simply gloss over those provisions because they are so important. The repercussions are major. So allow me to break them down section by section, in brief, no doubt. Section 11, I'm giving the gist of it. What does it say? Section 11 says, firstly, the Prime Minister and Cabinet shall continue to exercise executive authority. So no matter what, emergency or no emergency, in the context of this emergency, the PM and Cabinet shall continue to exercise executive authority. So it is also with the Mentris Besar and the Chief Ministers of the states. They will continue functioning as the executive in the respective states. And what else do we have there? Section 11 also says, the legislative functions to pass subsidiary legislation shall continue being vested in these persons. Meaning, despite the emergency, the executive branch is untouched. Not only untouched, its powers are augmented by the numerous provisions in the ordinance and in Article 150. That takes care of the executive. It's like business as usual for the executive, untouched. It exists as a branch of the government or state power. Section 12. Section 12 is a bit more difficult to read, but it is worthwhile analyzing it in depth. This has to do with the filling in of vacancies and calculating the dates when parliaments have to be called, and so on. So what does it say? Article 4, on the filling of vacancies in the Dewan Negara and casual vacancies in the Dewan Rakyat. It says, the normal time limits shall not apply. So that takes care of casual vacancies principally, and of course vacancies in Dewan Negara. Casual vacancies, Dewan Rakyat, and no vacancies in Dewan Negara shall not apply. Time limits will now be calculated from the date the proclamation of emergency is revoked or annulled. So you calculate it from that date. If it's annulled or revoked in August or earlier, then you calculate it from that date. Forget about the constitutional requirements. It's overridden now by the ordinance. Meaning to say you can expand the time a bit. Never mind. What does it say further? Article 55 of the Constitution is modified. Article 55(3) says, the life of Parliament shall be 5 years from the date of its first meeting, and then it shall stand dissolved. All these words are deleted. Again, I just pose the question, what does it imply? What does it really imply? Because there are certain things which we cannot state with some definiteness, because many of the things are going to be raised in court. Article 55(4), likewise, it's amended, basically, it's deleted. Certain critical words are deleted, because currently, when Parliament is dissolved, a general election must be held within 60 days, as we all know, from the date of dissolution, and it shall be summoned to meet not later than 120 days from that date. All these words are deleted under the ordinance. The ordinance now says, the general election shall be held and the meeting of Parliament shall be summoned as the Yang di-Pertuan Agong thinks appropriate, as executive thinks appropriate. all the time limits are gone. Right? So under this emergency ordinance. So I pose a few questions here. Are we looking at a scenario where the life of this parliament can be extended beyond 5 years? And thus the Prime Minister and the Cabinet can be allowed to function beyond the normal life of this parliament? I hope I'm wrong, but this is the reading that one gets by looking at all the deletions of critical words in the Federal Constitution. Thus, I can only conclude the current parliament is effectively suspended. And that suspension is indeterminate, since it can have a lifespan of more than 5 years. That's a logical sequence, logical outcome if we read those interlocking provisions. Let's look at sections 14 and 15. As far as Parliament and the Duns are concerned, here is the nub of the issue. For as long as the emergency is in force, all the provisions relating to the summoning, proroguing, and dissolution of Parliament in the Federal Constitution shall not have effect. Comes out very clearly. And Parliament shall be summoned, prorogued, and dissolved on a date the Yang di-Pertuan Agong thinks appropriate. No talk about suspension, yeah, but effectively we have a suspension, yeah, which means to say Parliament can be summoned, prorogued, or dissolved as executive thinks appropriate, on a date executive thinks appropriate. Further, there's a harder nub now. Any meeting of the Parliament which has been summoned before the coming into force of the ordinance is cancelled if it has not been held. So you may have dates fixed, March or whatever, it's over. It's cancelled. Right? So the executive will fix a date, right? As it thinks appropriate. The same formula applies to the Dewan Undangan Negeri under section 15, the mirror section 14. So to me, it is clear as daylight, yeah, that the current parliament and every Dun in this country are effectively suspended. I mean, I cannot come to any other conclusion, although it is not said so in the proclamation. Yeah, the provisions that we are looking at tends to the view that Parliament and the Duns are effectively suspended. Will they be suspended only until August 2021, which presumably is the date of operation of the emergency ordinance, being the terms of the proclamation of emergency? Again, I pose a question. The ordinance itself does not have such a limiting clause. It's in the proclamation of emergency, but not in the ordinance. Again, a few questions. Should it be done this way? Will it not erode parliamentary control under Article 150, Clause 3? How can the proclamation of emergency and the ordinance be laid before the Houses of Parliament for appropriate resolutions to be passed unless we have a Parliament that sits? How can we have it unless Parliament sits? So I will just stop here, Prof, because these are matters before the courts, as we speak, before the courts. Thus, I will not proceed further with any concluded views. I just raise questions so that people are informed and the thinking public will have some views on it. Yeah. Okay.
Okay, now we go to Dato Seri. Okay, so on for the questions. Okay, so I think that we might have a little bit of there's probably the relationship between the answer that you will give, okay, to what had been discussed by Tan Sri before. Okay, so the question that asked was the proclamation, as we know, will give the executive wide power to the extent of taking over state powers as well as undermining parliamentary rights, okay, except for what is not permitted by clause 6A under Article 150. Okay, so in this case, so this is like a hypothetical question to you, to Dato Sri. Okay, so what do you think will be the approach that the judiciary will take, okay, or should take, okay, and for the purpose of to protect the interests of the people, okay. And while doing that, can executive act as an effective control mechanism over the executive action during the emergency. Okay, so over to you, Dato.
I shall begin answering your question, Prof, by asking this question. Can a proclamation of emergency or an emergency ordinance be challenged in a court of law? In order to answer this question, let us go back into history. It is unfortunate that in the 1960s, our federal court, in the landmark case of Kalung Lincoln, mentioned by Tan Ariff earlier, was cautious or conservative in its approach and ruled that a proclamation of emergency was non-justiciable, meaning court cannot question, right? The two top judges then, Lord President Syed Sheikh Barakbar and Chief Justice Azmi, said that the Yang di-Pertuan Agong was in quote, the sole judge in regard to a proclamation of emergency. But then there was a very strong dissenting judgment by the third member of the bench, namely Justice Ong Hot Tai, who said in very firm language, which I would like to share with you all this evening. This unquote, Article 150 does not confer on the cabinet an untrammeled discretion to cause an emergency to be declared at their whim and fancy, according to the view of my learned brethren. And here he's referring to Lord President Syed Sheikh Barakbar and Chief Justice Azmi. According to the views of my learned brethren, however, it would seem that the cabinet have it's a French word, I hope I pronounce it correct, carte blanche. Well, it means a blank check to do as they please. A strange role for the judiciary, who are commonly supposed to be bulwarks of individual liberty and the rule of law and guardians of the Constitution. Bear these words. Supposed to be bulwarks of individual liberty and rule of law and guardians of the Constitution. Now, some 10 years later, in the landmark case of Teh Cheng Po, this is 1979, the Privy Council left open the issue of the justiciability of a proclamation of an emergency. The question was posed to the Privy Council, but they say, for purpose of audition, we don't not necessary to answer this question. So they did not answer the question. The question left open. Thus, the question now is a proclamation of emergency or emergency ordinance justiciable or non-justiciable? In other words, can they be questioned in the courts? In this regard, it must be pointed out that in 1981, some drastic amendments were made to Article 150, giving unbridled power to the executive to declare at will and to perpetuate emergency rule. Notably, there is fundamental change brought about by a new clause 8 to Article 150, which provides as in essence, I won't read out the provision. In essence, that a court of law cannot question the constitutionality or validity of an emergency proclamation or the promulgation of an emergency ordinance. Now, the pertinent question is, should the executive be granted a blank check in the name of emergency? In my view, the rule of law requires that a court of law must have the power to review any proclamation of emergency or any promulgation of any emergency ordinance. Otherwise, the executive will have a blank check in proclaiming emergency or in promulgating emergency ordinance. And the judiciary, if it prefers to do nothing but a mere mute bystander, will be filling in its role as, to quote the word of Justice Ong just now, its role as bulwarks of individual liberty and rule of law and guardians of the Constitution. There will be no checks and balance in the system. This untenable situation may lead to an eclipse of constitutional government. In this regard, I must say that the judiciary must be pro-judicial activism. Now, what is meant by judicial activism? It is difficult to define what is judicial activism, but what I will say is that judicial activism is an interpretation of the law that is not literal, but is creative. An interpretation that breathes life into the law, a decision that is positive and takes into account the social needs of the time, whilst at the same time being hit with the principles of justice and the legal and constitutional framework within which the decision is made. Judicial activism today is a reality and generally accepted as a legitimate exercise of judicial function. It is recognized as being part and parcel of the role of judiciary as being co-equal with the other two arms of government, namely the legislature and the executive, and as being essential to good governance and a system of checks and balance. Our judiciary, although known to be conservative in the earlier years of our independence, yet lately have shown to be pro-judicial activism, as manifestly demonstrated in the following landmark cases. Number one, Sivarasa Rasaya, decided in 2010, Semanis Jaya, decided in 2017, Indira Gandhi, decided in 2018, and Almanudo, decided in 2019. Almanudo was a strong panel of 9 judges. In these 4 cases, the federal court courageously and commendably initiated the doctrine of the basic structure of the Constitution. Now, this doctrine of the basic structure of the Constitution in essence provides, among others, that the judicial power of the Federation vested in the judiciary is part of the basic structure of the Malaysian Constitution and cannot be taken away by Parliament, even by way of an amendment to the Constitution. Now, having discussed judicial activism and the doctrine of basic structure of the Constitution, let's go back to Clause 8 of Article 150. Based on the doctrine of basic structure of the Constitution, and that the court's power of judicial review is part of that basic structure that cannot be taken away even by an amendment to the Constitution, perhaps an argument can be made out with force that Clause 8 of Article 150 is unconstitutional and ineffective in precluding the courts from reviewing the constitutionality and validity of a proclamation of emergency or the constitutionality of and validity of an emergency. I'm not saying, please take note, I'm not saying that that is so, that's the position in law. I'm saying that an argument can make a force. It's only an argument. Yes, right. In other words, notwithstanding Clause 8, our courts could, for example, inquire into a claim that a proclamation is fraudulent legis, meaning an allegation that the proclamation was not done in good faith. It must be stressed here that although it's made in the name of the Yang Dipertuan Agong, the truth of the matter is that in reality and as a matter of constitutional requirement, the Yang Dipertuan Agong acts on the advice of the cabinet. So when a claim is made that a proclamation is made in bad faith, that allegation actually is leveled at the cabinet and not at His Majesty. Let's take another example. a challenge on emergency ordinance could also be made on the principle of proportionality. Under Clause 6, an emergency ordinance could deprive a citizen of his right to fundamental liberties, like the right to free speech, freedom of movement, freedom of association, freedom of assembly. But any restriction or deprivation in excess of these rights by citizens must be proportional. It must have a nexus to the mischief. So in the current case, what is the mischief? The mischief is the COVID-19 pandemic that brings about a grave emergency situation. So, any curtailment of fundamental liberties by way of an emergency ordinance that has no nexus to the mischief at hand would be contrary to the principle of proportionality and could be declared null and void by the court. To summarize on your first question, Prof, the approach which should be taken by the court is that the emergency ordinance and its provision must be scrutinized strictly because they are inconsistent with fundamental liberties provisions in the Constitution, and that principles of law or grounds of review, such as the proportionality test or bad faith principle or the improper purpose doctrine, must be applied by the judges with judicial activism. Only then public interest can be protected. And now I come to the second part of your question, Prof. Can the judiciary act as an effective control mechanism during emergency? My answer here will be short because there are going to be some overlapping with my answer in the first question. Now, my answer is certainly the judiciary can act as an effective control mechanism, provided that it is pro-judicial activism, that it has the courage and creativity to do so. The principles are there, as I've explained earlier, and I've named some of them, namely the doctrine of basic structure, the principle of freedom logis, and the principle of proportionality. Whenever there's a complaint of an infringement of fundamental liberties, it is then the court's duty to inquire. It is then the court duty to inquire the alleged infringement arises and to scrutinize the act of the infringement complained of, as well as making the necessary remedial orders. In doing so, the court is to examine and evaluate the alleged act of infringement in the light of the principles explained earlier. If the judiciary takes this position and performs its duties in accordance with the above courageously, then, in my view, it can be an effective control mechanism. My only worry is whether some judges are willing or courageous enough to explore this area of the law and in making their decisions. At the expense of repetition, allow me to stress here again that the judiciary must not abandon its responsibility to be the bulwarks of individual liberty and the rule of law and guardians of the Constitution. The handicap in the judiciary is that until and unless a party files an application to the court, so the judiciary must wait for somebody to bring the matter to the court. The courts and the judges cannot lend a hand in acting as a control mechanism, or better known as checks and balance. And finally, I'll be brief now, Prof, coming to the end now. My view is therefore for the lawmakers to consider seriously amending the Constitution to bring back the constitutional safeguards that we once had immediately after independence, and perhaps with further improvement in the safeguarding provisions. For example, Article 150 Clause 3 in its original form imposed an expiry date of 2 months for a promotion of emergency and 15 days, as mentioned by Tan Sri Ariff, and 15 days for any ordinance promulgated from the date the Parliament first sitting. In 1981, Clause 8 was also amended into Article 150, resulting in an ouster clause preventing the courts from adjudicating matters pertaining to Article 150. In my view, these provisions must be amended further for them to return to their original forms or to improve further. Thank you.
Thank you, Dato Sri. I think that's a very good closure for the. But we have to wait for Parliament to be called and have the sitting, isn't it, in order to propose for the amendment. So with that, okay, I think I would like to invite Tan Sri Richard, one of our special guests tonight. Okay, so after listening to the whole discussion tonight, okay, so probably Tan Sri Richard would like to give your viewpoint, okay, on certain aspects of the discussion and your opinion on based on the evaluation of the proclamation and Article 150 as well as the 2021 Emergency Ordinance.
Thank you, Prof. Good evening, and to Tan Sri Ariff and Dato Hisham and all listeners tonight. Yeah, and also thank you to Reforms for extending the Zoom link to me. Thank you very much. Now, I've heard both parties very interesting, enlightening presentations. But preliminary, I would like to ask one or two questions first on the panel. One is this: the ordinance itself was made under 150(2)B, but I would have thought that there should have been a proclamation first, and that's under 151, because 2B speak of when proclamation is already existing, and only you do an ordinance. But if there had been no proclamation on 1501, and where does the present ordinance stand? I couldn't find a proclamation being made under 1501. Yeah, I may be, I may be a bit out of date, but I was looking for it even online. I couldn't find. I have to be forgiven if there is one and I miss it, yeah. But that's the first question that I'm wondering, because if there is no proclamation on 1501, and 2B shouldn't be there to begin with, yeah. That's one. Two, what is the effect of that proclamation or that ordinance? It has a far-reaching effect, if I may say. If you look at the ordinance section 18, I think the end section, it says all-encompassing provision. Yeah, it says any written law that is contrary to this is bound to be superseded. Meaning to say that written law includes the Constitution, the state and federal Constitution, and therefore any provision in the federal and state Constitution that is contrary to that ordinance is for a moment superseded. So that is to me is a far-reaching implications. Yeah, that's to my view. I may be wrong, but looking at it as the question that to Hisham expressing. So that's the position that I must say. And where does the Constitution stand now? Of course, again, I must refer to that Hisham. Article 4 is very clear. That is where it says the Constitution is the supreme law of the land. What is the point of being a supreme law of the land if it can be amended today, tomorrow, the next day? And that is where Article 1591 of the Federal Constitution must be read, yeah, in conjunction with Article 4.1. With all due respect, quite a number of writers have missed that. But if you look at, they keep on saying that 1591 is literally dilute everything. With all due respect, I think that is a wrong view, because as Tuashim says, Article 4.1 speak of the supremacy of the Constitution, and that is where the doctrine of separation of powers and all those basic foundational doctrine stays. So and the judicial powers and so forth, and that is where I think that has been missed. And any therefore federal law being enacted which is contrary to the Constitution, and that would include the contrary to the basic structure of the Constitution, is null and void. Now, going back to the ordinance, ordinance was proclaimed, as I said just now, under 150, isn't it? And in this case, we are looking at ordinance of Med 2B. I don't know. Ordinance has not been defined in the Constitution, neither in the Interpretation Act. The only definition of the ordinance is in the Interpretation Act on ordinance is the legislation made by the Sarawak Assembly. So, but not on ordinance here, you know. And if you look at Article 160 of the Constitution, it doesn't define what ordinance is. Law, yes. Law includes written law, and written law includes the Constitution and the said Constitution. So these are things that has been, disturbing my mind. Where does it stand now? And if they just pass the ordinance pursuant to 2B without consideration of 1501, and then they may have failed the test of the grave existence of a grave situation and so forth in clause 1 of Article 150. So there you are. So these are questions I think that law student or law academia or even judges may be playing in their mind. Be interesting. So basically that's my short comment on the two papers, but otherwise they are very, very interesting, and I have taken down quite a number of points which not that I intend to use it, but good for knowledge. Thank you, Prof. Thank you.
Thank you, Tan Sri Richard. So any of the panelists want to respond to that? To Tan Sri
Richard? I just mention something with raised by Tan Sri Richard on the proclamation. Actually, the proclamation does refer to Article 150, Clause 1. It's here. So it is.
I didn't. I got a copy of the one in the online, and it only refers to 2B. Is there?
It's the ordinance, but the proclamation itself is 1501.
Oh, there is, okay.
It's there. It's in there.
All right. Okay. So I missed that part. That's why I was looking for it. I said there must have to be a proclamation first before the.
But you've raised a very good point, Tan Sri, because we have not read the fine print in Section 18. Section 18 is the equivalent of the ordinance pulling itself by its bootstraps.
All right. Interesting. Very interesting otherwise. Okay. All right. Okay. So, Prof, thank you.
Dato Sri, anything to add on that?
I just saw something very. I've been looking at the proclamation. Proclamation too. Now, on the one hand, EO, the Emergency Ordinance suspends Parliament, but look at the fine print below the proclamation. The fine print in square brackets. The proclamation.
Okay.
I shall read. To be laid before Parliament pursuant to Clause 3 of Article 150 of the Federal Constitution. To be laid. On the one hand, to be laid. On the other hand, EO suspend Parliament. So the question is.
Good point.
I saw that.
Yeah.
Now my only comments. Thank you, Tan Sri. But in a general response to your points tadi, I think it all goes back to the doctrine of basic structure, lah kan?
Right.
Curtail fundamental liberties and all that. But at the end of the day, it cannot impugn the basic structure of the Constitution.
Right.
But I wish to raise one point. But correct me if I'm wrong. Of all the cases that I've seen on justiciability, they mention a reserve position can be challenged if it's in fraudum legis. There has been no case to say that even on this ground it cannot be challenged.
But I thought in Ninkan case, the Privy Council did say that if there has been some fraudulent intention involved, and then there's a nullity or something like that. If my memory serves me right.
That's right. That's right. So it's still available for lawyers to show that this is being done for a collateral purpose. In fact, there is another aspect of it, because the current developments seem to indicate once you cannot challenge the head of state, you can't challenge because of prerogative powers, or in our case, because of the position of His Majesty and within the Constitution. You can actually challenge the advice being offered to the Yang di-Pertuan Agong, straight out from the Miller's case, which has been approved by the High Court recently. In the case where I was sued as Speaker of the House, it was approved. But of course, that case, you say, well, it's all right. So the cases that we're going to see being fought out in court is going to be very interesting for the constitutional lawyers, academicians, and the retired judges.
Yeah, why not?
Okay, thank you, Tan Sri.
Thank you.
I received quite an interesting questions from our audience. Okay, so I will pick this. So this is, I think this is addressed to Tan Sri Ariff. Okay, so it's relating to the role of Parliament. Okay, so the soalan dia adalah sejauh mana fungsi Ketua Pembangkang dapat diamalkan dalam tempoh pelaksanaan darurat, dan sejauh mana peranan Ketua Pembangkang diiktiraf beraku oleh Yang di-Pertuan Agong dalam tempoh darurat, atau adakah dia itu tidak berfungsi sama sekali? So that's, I think, quite an interesting question.
Yeah. Boleh saya jawab dalam bahasa Malaysia atau dalam bahasa Inggeris? Soalan dalam bahasa Malaysia.
Dia tanya dalam bahasa Malaysia. I think you can answer in English too, because
English,
at the end he also writing in English. Yeah.
I think the short answer to the question, which is a very good question, is unless Parliament sits, nothing comes of it. To have leader of the opposition speaking outside Parliament is not quite the same as a leader of the House debating in Parliament, questioning in Parliament, representing the opposition MPs as head of the opposition in Parliament. It's not quite the same. So that is why we must have Parliament being summoned to sit. Actually, aside from 1969 to 1971, throughout the constitutional history of our country, there has not been a case where Parliament has not sat or Parliament has been suspended during a time when an emergency has been declared. I mentioned earlier 1977, Parliament was sitting. 1966, Parliament was sitting. That's how Parliament could pass all those acts, especially in the Ninkan case. They passed the acts, to temporarily, amend the Constitution of Sarawak. Parliament was sitting. So there is no reason, actually, in logic or whatever, not to allow Parliament to sit. And when Parliament sits, then of course MPs, including the leader of the opposition, can perform all the normal functions, the oversight functions of MPs. It's not only about making law. It's not only about passing a resolution of no confidence or confidence or whatever. It involves other things. Questioning action taken by the executive through question time. Debating bills, very intensively can only be done on the floor of the House, or engaging with the executive in the committees. But if Parliament doesn't sit, you can say, oh, the committees are there. They can still meet in committees. It's not the same. Committees can meet if allowed, but they have to produce reports. So they table the reports at home, just laid on the table again, without Parliament sitting. It doesn't work that way. So that's why it is imperative for the good of this country, yeah, for the image of this country, for the executive to take steps to summon Parliament. Because that's the only way I think we should go about it. It doesn't matter whatever complications there are or not. But if we believe in a constitutional system, if we believe in parliamentary democracy, if we believe in the separation of powers, this is the way to do it. And this is the way it has been done over the years. So I don't know what's so special about this present emergency that we cannot have Parliament sitting. But you know, we've been talking about this present proclamation of emergency, but we forget there were 3 emergency proclamations even before the one that we are discussing today. The one relating to the by-elections, you remember Batu Sapi and the 2 others? They were all declarations of emergencies. And ordinances were passed. And the irony is, Parliament was then sitting, or summoned to sit, may not sit physically on the day, you know, those things were done, but certainly Parliament was not prorogued. You know, Parliament was sitting. Parliament was not dissolved, it was there. The Parliament was there. So now, Parliament has been adjourned sine die. It has not been prorogued. From the information I've got, it has not been prorogued. Parliament has not been terminated. Let alone dissolved. We can only dissolve in different circumstances. So if the executive wants it, they can always advise the Yang di-Tuan Agong to summon Parliament to sit. You know, it's there in the ordinance anyway. So this question of whether you want to use it, you know, properly or you don't want to do it. Yeah? I think to answer the question in a slightly roundabout way, I mean, this is how the leader of the opposition could be seen as having augmented, you know, in a role in the context of Parliament. It has to be done within Parliament. Yeah.
Thank you, Tan Sri. I think there's another question. Like I think this will be appropriate to be answered by Dato Sri. Okay. So because the question read, okay, in view of the Auster clause, what rights would citizens have if they choose to challenge the ordinance? So that's the question.
Well, citizens can challenge the ordinance, we have to go back to what I said earlier. You must have a basis to challenge in view of the Auster clause. You have a basis. So what is the basis? We'll go back to what I've said earlier. You have to invoke the doctrine of basic structure of the Constitution. That the doctrine or the basic structure of the Constitution, the effect of that doctrine is that the Auster clause simply does not work because it goes against the basic structure. So regardless of the presence of the Auster clause, it does not prevent a citizen from challenging the legality of the ordinance. So that would be my short answer to the question. Thank you.
Okay, thank you, Dr. Sri. I think we have this question have been answered by Tan Sri just now. Okay, where I say like the question. Okay, I just whether I'm going right or not. But okay, Tan Sri, the question read, sama ada aktiviti special select committee masih boleh diteruskan atau tidak sekarang? So that is the question.
Ya. Yang betul Dewan Rakyat telah mengeluarkan kenyataan bahawa boleh berfungsi. Tapi pokoknya kalau berfungsi tapi tidak ada kuasa untuk membentangkan laporan secara berkesan, saya kira tidak ada tak banyak makna di situ ya. Dalam keadaan emergency ini, walaupun mungkin boleh pada dasarnya, tapi tidak berkesan. Macam PAC misalnya. PAC harus dipanggil bersidang. Tapi mood emergency ini tak begitu baik lah. So we must allow Parliament to function in the best way possible. It's not only about COVID. It's about so many other things. It's about taking care of the nation's coffers, making sure that monies are well spent, and so on and so forth. The people are held to account, wastages, things like that. Whether development plans have been carried out properly, myriad of things can be raised in Parliament, but are now not raised because Parliament is not sitting. So anyway, it's all tied up with the previous question.
Yeah. I think this is last one question, another question. Okay, will be forwarded for Dato Seri. So I would like to direct a question about the exclusion clause. In cases of Sugumar, Ambiga, and Maria Chin, the court held that exclusion clause should be interpreted in accordance with Parliament intent. Thus, the clause shall be valid. So, does the exclusion clause to absolve government from any action and also the compensation be safe under the said clause? So, what do you think, Dato Seri?
Before I answer this question, just to add a little bit for to my answer to the earlier question. Now, invoking the doctrine of basic structure, one would only giving the court the jurisdiction to hear your complaint. But in bringing a complaint to challenge the ordinance, you must have what we call a cause of action. So you must have a cause of action. So what is the cause of action? For example, is it on the basis of fraudulent lodges? Okay? Or is it on the question of proportionality? So in order to challenge the ordinance, after saying that the court has jurisdiction by invoking the doctrine of structure, you must go on to state your actual complaint. What is it? And it must be, you must have a cause of action. Yes, as I've explained, right? Now, coming back to the case of Maria Chin, right?
Yes, Maria Chin.
Yes. There, it is not a unanimous judgment. It's a 4 against 3. We have our judiciary have in all the 4 cases that I mentioned earlier, okay, Sibarasa, Semnya Jaya, Indra Gandhi, Al-Manudo have all emphatically reaffirmed the principle of the doctrine of basic structure. That means you cannot take away the the power of judicial review of the courts. Meaning, you cannot ouster clauses are not lawful constantly, because ouster clauses, it tends to take away the jurisdiction of the courts, and that goes again the doctrine of basic structure. Now, in Maria Chin, I think I recall correctly, it's a 4 against 3. The majority says that the doctrine of basic structure as propounded by our courts are all obiter dicta and not ratio decidendi. But I think this is going to be rather going into, I won't go into academics, but I think the doctrine has been affirmed from time to time by the cases. And I hope one day in the future, the federal court will have the opportunity to reassert again this principle of doctrine of basic structure. In Maria Chin, is only a majority of 4 against 3, and it has to be noted that the Chief Justice is in the minority. the Chief Justice is in a minority. So I hope in the future, this principle will be re-edited again by our courts. Thank you. Yeah.
Thank you, Dr. Sri. I think we have, I think, quite an hypothetical question here. Okay, so I think this question is asked for Tan Sri Ariff. Okay, so it say like, if the current speaker of the Dewan Rakyat were to share the same views as yours, meaning that as Tan Sri, okay, that meaning that which you say that Parliament can or shouldn't be suspended by an emergency proclamation and the ordinance promulgated, would the speaker have the legal basis or discretion to refuse to accede to the suspension and continue holding parliamentary session of the Dewan Rakyat as scheduled? Oh. And would such opening and continuation of parliamentary session be justifiable, even if it might contradict Article 555 that Parliament must be summoned by the Yang di-Pertuan Agong? And quite hypothetical, but I think it probably, it's probably relevant here.
Yeah, we are talking about our constitution, so we have to abide by the provisions of the constitution. The speaker does not have the power to summon Parliament independently of the Yang di-Pertuan Agong, who acts upon the advice of the executive. That is how the system works. I think to give too much power to the speaker also may not be too good, a situation, the position to take. So the answer is no such power. Such power. In certain circumstances, maybe speaker can refuse when the leader of the house requests for a sitting, as I did and got condemned for it. These are kind of a localized areas where the speaker has a bit of discretion. But for big things like summoning Parliament, it's very clear. Only the Agong can summon or prorogue Parliament. Yeah, that is why it's a major thing. Maybe I should explain a bit before we end. I suppose the meaning of prorogue as opposed to adjournment. Yeah, and adjournment at the end of the day, last day of Parliament, the Speaker will say ditangguhkan ke satu tarikh yang akan ditentukan kelak. Adjourn sinadai, it means in English. It's an administrative function. Which is where we are now. But prorogation is different. There are technical effects to prorogation. Prorogation is where you have a formal declaration or proclamation by the Yang di-Pertuan Agong ending a meeting or a session of Parliament. So normally, Parliament will meet until December, and then February or January, the Agong will issue a proclamation of prorogation of Parliament, meaning that current Parliament's business is done, is terminated, after which it will be summoned again. Then there will be an opening of Parliament. Yeah, very technical terms, but there are repercussions. For instance, when you prorogue, all the usuls, the motions lapses. The Parliament is sort of closed shop. It ends its business, but not bills though. So the bills will be carried forward to the next session. Yeah. So this is how it works. So Speaker has got no say in these matters.
Okay. Thank you, Tan Sri. I think that's some of the questions that we got. Most of other questions have been already answered. Okay, because it's like a similar questions to what have been asked. Okay, so thank you. Okay, for all speakers and also our special guest. Okay, Tan Sri Richard. But before we end, I would like to give like 2 minutes. Okay, for each panelist and our special guest. Okay, if there is anything that you want to add. Okay, and conclude. Okay, with your presentations. First, Tan Sri Ariff.
Yeah, I wish to state very generally that the Constitution exists for a purpose. And I think it's incumbent on all of us, citizens as well as those in government, high level or low level to understand this purpose. It is a document of destiny, as of one of my professor friends has said. It is a document also for constitutionalism, for democratic arrangement of government, for good governance, and so on. So we must understand the purpose, and once we understand the purpose, we should abide by the spirit of the Constitution. Now forget about all this legality. Is good to argue in court, but all these problems will crumble if everyone understands the spirit of the Constitution. Like you should only have a declaration of emergency when there is an emergency, things like that. And you mustn't have outside clauses because it's not good for governance. Things like that. Yeah. So I think whilst we discuss all these hot issues, let us not lose sight of the overall overarching purposes of the Constitution. After all, lots of people have said in the constitutional law is just regulated politics. So we must regulate our politics, because otherwise, once it gets unregulated, it's not good for the system. Yeah. So I conclude on that note.
Thank you, Tan Sri Ariff. Dato Sri Hisham?
Very shortly, Prof. Number one. Well, it's my earnest hope that seeing the emergency, I do hope that our Parliament, for the sake of good government, will be summoned by His Majesty and meet as soon as possible to consider both the emergency proclamation as well as the ordinance. Yeah. Because that is the spirit of Article 150, parliamentary oversight of executive action during a state of emergency. Number two, I do hope when the condition permits, our parliament will seriously consider to re-amend Article 150, which has been much watered down over the years and given untrammeled powers to the executive during a state of emergency, to reconsider, bring it back to the good old days, where there is a parliamentary oversight, and perhaps with some improvements, with a view to safeguard constitutionalism. Thank you. Yeah.
Thank you, Dato Sri. Now to you, Tan Sri Richard.
Oh, thank you. Last, as well, of course, I must again thank the organizer, reforms and all that. Yeah? Hopefully, there'll be more discussion like this, academic discussion. And hopefully for those listeners, don't take it to heart if a certain comment is made, because we all know that there is a pending case and we don't want to be cited for contempt on the ground of sub judice. That's one. Two, we all accept the fact that COVID is really doing a very harmful effect on the society. Yeah? We have to accept that fact. But at the same time, we have to ask a question. By imposing an emergency, by proclaiming an emergency, does it solve the problem of COVID? Or it needs a scientific approach rather than legal approach? We have to go together hand in hand on a very reasonable scale. These are questions that I think we should ask, because just by declaring a proclamation of emergency, it's not a magic word. Then the COVID world, we run away. We're scared of being detained. COVID virus, that cannot be right, is it not? So these are things. And meanwhile, the consequences of the proclamation may be far-reaching effect, not only today, but it may be affected in days or months or years to come. So these are things that I think we have to bear in mind. And I associate myself with the comment, concluding remarks by Tan Sri Ariff and Dato Hisham, on the importance of safeguarding the Constitution. Thank you very much.
Thank thank you, Tan Sri Richard. So now we come towards the end of our session. Okay, so I would like to thank all our speakers and our special guests tonight. Okay, so this is a very interesting discussion. Okay, I think it's very engaging, and okay, it's very intriguing in the sense that okay, we are looking at the provision itself. Okay, so we are not discussing it from political perspective or just economic perspective, but this is a legal analysis on okay Article 150, okay the proclamation, okay, and also the Emergency Ordinance 2021. So this is just to not to provoke or to instigate okay the public okay to go against this, but okay for us just to think okay on the necessity, the proportionality, okay the reasoning behind okay of having the emergency, and whether there are any other ways that we can actually find okay in order to curb okay the COVID-19. Okay, plus any other problems that we might have in our country. So because we can't sort of like treat okay a sickness okay with the wrong medicines. Okay, we have to try the right medicine to treat the disease. Okay, so if not again, the disease might prolong, or probably will die okay out of it. Okay, so that is okay things that, and I hope okay. This discussion give a good insight okay to those whether they come from a legal background okay for general public or those okay people with a high academic qualification to understand and at least appreciate okay the worries that okay some certain segment okay of the society have, because I think in a diverse nation like Malaysia, in which we are not only diverse in terms of race, religion, but we are also diverse in sense of thought. That is when we try to understand issues and problems. So this discussion can be taken as an eye-opening and as an assistant to understand and to find resolutions to the dilemma or the questions or the mystery that we are trying to solve at the moment. So thank you for all to all speakers and I hope we'll wait for reform. They will come with upcoming discussion which will very interesting, mind provoking, and I think we just because youth they have many questions in their mind, therefore we have to make sure that we provide a good platform for them to raise their voice, ask what are their concerns. So thank you again for all speakers, to all our viewers tonight. I hope we don't confuse you further and you find that the discussion is beneficial to all of you. Thank you very much. Good night. Assalamualaikum, and have a good rest to everyone.
Good night.
Bye.
Good night.